When I talk about lease mistakes, I'm not talking about misspellings or bad formatting. I'm talking about these big money matters, the kinds of mistakes that wreck tenancies, all of which are preventable if you know what you're doing right from the start. Today we're talking all about the 5 most common lease mistakes that landlords make and what you can do to avoid them. Let's get started. So one real common error is simply using your name as the landlord in your lease. If you're going to operate as a business, you really want to learn how to operate under a business name, and you're going to want your rental properties distinct from your personal assets. You don't want to commingle your rent funds with your personal funds or your rent income with your personal income. When you're running a professional landlording business, you're going to want a bright line in between them. And so one of those easy ways of doing it is to, set up an entity, set up something that's distinct from you and your personal stuff. Because you may own 1 or 2 or 3 or 4 cars, a house, a boat, other things that are titled in your name as an individual, but you want your rental assets, everything having to do with your landlording work, to be separate and distinct. And whether you have a single entity that controls all, or even smarter, you have multiple entities set up, one per property, to not only distinguish them from you, but also to distinguish them from each other, and never let one rental contract take down the whole lot. You certainly don't want to claim in one of your rental properties to have some kind of adverse effect on your personal assets. So at the very least, even if you just have one rental property, you're going to want a line of distinction between yourself and your company. Certainly, if you have more than one property, you're going to want to talk to somebody about setting something up to create a line of distinction. You don't want to operate in your own name for all time. Maybe when you're first starting out, maybe if you just got the one, but even it comes with some sort of risk. So anytime you sign a lease, you open yourself up to potential litigation. And what you don't want is for that litigation on the business side to have a negative impact on your personal side of things. Get away from using your own name as the landlord in your leases and come up with a holding company, come up with multiple companies as needed as your business grows, to make sure that you are operating in a business-like manner instead of an amateur manner. Remember, you want to operate like a business professional. A landlording pro starts using a business name and no longer uses their individual name when they are signing leases. Don't be so eager to sign a lease with someone that you forego collecting the deposit, or you agree to take the deposit over time. That is a mistake. And the reason that it's a mistake is because the person is indicating to you they cannot afford your rental. If the difference between success or failure of a particular tenant is their ability to pay the first month's rent and the entire deposit, they're already telling you they're on shaky ground. And don't let somebody convince you, hey, times are tough and we're living in unprecedented times. Really, that's just shorthand for I'm barely making it. And instead of doing the responsible thing of renting a less costly place, I'm going to max myself out and I'm going to be unable to pay the deposit, which is an indication that they're really about one emergency cost away from defaulting on that rent. You want someone in place who can not only pay the first month's rent, but who can handle the deposit, and it doesn't, wreck their finances. By having somebody in place who is, again, on that razor's edge, you're going to put yourself at risk of at some point having to deal with a default, which inevitably is loss for you. So don't cut corners when it comes to opening up a new leasehold and, taking from a tenant the excuse that it's simply too hard to come up with a full month's rent and a full deposit. If that's the case, you should stop things where they are and say, look, this lease doesn't go if we can't collect both right at the start. Use that as an indication that your tenant is telling you, I simply can't afford to be here, and go to the next available applicant who can pay the first full month and the entire deposit up front right from the start. The next thing that landlords get wrong a lot has to do with late fees. And it comes down really in two parts. It's either A, they don't know how the late fee provision works, or if they do, they don't ever enforce the late fee provision. Both of these are mistakes. You want the late fee, number one, to be prohibitive. If you're charging a tiny late fee and then a tiny daily amount thereafter, it doesn't sting to pay a minimal cost if it means they can hold on to their money longer. Instead, what you want is for the fee itself to be prohibitive, for them to think twice about delay on that payment, because you're going to charge them a very high rate. But you better know what the maximum rate is, and you better not overcharge your tenant, because that could also lead to problems. So make sure you understand what your jurisdiction requires and what makes sense for you. In Texas, for a single family home, a landlord is restricted to 12% of the monthly rent. So if, for example, a particular rent is $1,000, then the maximum amount of late fee is $120. So it doesn't make sense to make a $25 late fee and then $10 thereafter, going on until you reach that $120 maximum. Instead, I suggest that the first day of late fee be a $40 fee, and that you collect the entire late fee by day 7. In Texas, we're prohibited from collecting late fees on the second or the third day. So if rent's due on the first, on the second or the third day, can't really collect any late fees. But on the fourth day, I would suggest hitting them with 3% of the rent, because you get 3, 3, 3, and 3. So by day 7, you've maxed out 3, 3, 3, 3. That's 12% of the rent. By day 7, you've maxed out on the total amount you can possibly collect. And if you still don't have the rent on that day, I would further suggest you issue a notice to vacate, because once you get to day 7, inevitably a tenant paying rent on the 7th or later is likely going to pay the next month late as well, if not later, and that's just going to have a snowball effect throughout the tenancy. Now, for those of you who know how your late fees work and simply don't enforce them, you're condoning bad behavior, and I don't recommend it. Aside from the mere fact that you're entitled to get more money out of your rental than you were otherwise expecting, you're encouraging your tenant to pay whenever they want to, and that is never going to work out well for you. Instead, you should let your tenants know, look, not only is there a late fee provision, but I understand it well and will enforce it to the letter. They should know this before the lease ever begins. Not enforcing it is a mistake, and the even bigger mistake is enforcing it but not knowing how late fees actually work, because you're likely going to get it wrong and you may get sued over it. So figure out how late fees work in your jurisdiction, understand what your lease says, and enforce those late fees. Do it in a way that makes sense. Again, you want them to be prohibitive of late payments so that you enforce them and hopefully prevent future late payments. Another common problem that landlords cause themselves is that they fail to apply payments in a logical way. I talk a lot about the application of funds clause in your leases. Go through your lease. You probably have a provision in your lease that says something to the following effect. I can apply payments first to non-rent obligations like fees or repair costs or HOA fines, etc., etc., etc. And then any remaining balance goes to rent. So that if your tenant is simply refusing to pay fees or fines or repair costs, that's not a problem if you are applying that payment, whichever they make, to those things first, and then the balance to unpaid rent. If it turns out that they've made a payment, refusing to pay anything more. Well, now they've got a non-payment of rent issue, and you should be issuing notices, either a notice of default for failure to fully pay the rent, or a notice to vacate and telling them, look, you're expected to pay. We're at day 7 and you haven't paid the full amount. You now have to leave. And so you want to understand the application of funds clause and not be in the following situation where we're at the end of the lease and you've got $1,000 worth of unpaid fees, repair costs, and HOA fines, and you've got another $1,000 of damage to the property, but you're only holding $1,000 in the security deposit. By waiting until the very end of the lease and not applying payment and scrubbing old debt first, by leaving gaps in your ledger of payments and just applying a payment strictly to rent, you're going to find that at the end of the lease, the deposit is going to be insufficient to cover all of the fees, all of the fines, all the repair costs, and then the new repair costs that are there at the end of the lease. By setting yourself up for failure like this, you're going to lose money. However, if you hold your tenant to everything due, as soon as they make a payment, you apply those fees first and you clear them off your ledger as paid. And then if a rent balance persists, you inform them. And if they insist that they will not pay, then you get rid of them. Don't allow them to accrue debt. Don't allow gaps on your payment ledger, and don't wait to the very end to resolve these things. These are common mistakes that are easy to fix, and you should be on top of them earlier rather than later. Finally, and this one just bugs the heck out of me whenever I see it, a common lease mistake comes at the notice section of the lease. Too many leases simply either A, leave the notice provision completely blank because they don't anticipate it being a problem. Oh, I've got their number on my phone and we text each other all the time. However, the lease doesn't indicate that text communication is an acceptable form of communication and therefore may not be. Also, what happens if they ghost you or they stop responding? That could be a problem. It could be as simple as their phone has died or they lost it. But if that's your only means of communication, that's a problem. And so instead of having 0 methods of communication or just one, I encourage landlords to have multiple means of communication. You might want a private email, a work email, a cell phone for each of the adults who signed the lease. So mom and dad, you've got 6 just right there. You might also have a tenant portal that you can use where repair requests are made, but where notices can be sent. And then, of course, you've got the old-fashioned US mail. So what you don't want are fewer options. You want multiple options. Do they have a fax machine? Well, there you go. There's another method. Can you text them? Make sure your lease mentions that text communication is a method approved by both parties and that those numbers are mentioned in your lease. So work email, private email, text, your portal if you have one, if you have some kind of instant messaging app or some other means to communicate with your client, make sure that it is in the lease so that you and your tenant have not just one, but multiple avenues of communication. When things are great, you're probably going to stick to just the basic one. When things fall apart, you're going to want to be able to prove that you sent notice to them and that you sent it through various mechanisms so they cannot later say, Your Honor, I never got that. If you mailed it to them, emailed it to the work, to the personal email, to the spouse's work and the spouse's personal email, and you texted everybody, it's going to be very hard for them to convince a judge they were not in some way properly notified. But you have to take the steps of putting that information in your lease from the beginning. I hope you found today's talk very helpful, and so that the next lease you sign is tip top. You don't want any of these unforced errors when it comes to your lease, whether it's from the way that you draft it, the way that you fill it out, or the way that you operate it in your enforcement. You want to make sure that you are on top of it always, so that not only you're making the most amount of money, but that you have the clearest, most precise expectations laid out for your tenant. That always means a better tenancy. If you enjoyed what you saw here today, I kindly ask you for a like. If you got a question or a comment, leave that below. And if you're not a subscriber yet, please consider subscribing. We have a ton of videos on this channel, and I welcome you to check out as many as you please on topics spanning all sorts of things having to do with landlord-tenant law, deposits, repairs, evictions, all of it here on this channel. In fact, YouTube seems to think that this video right here is the next best thing for you to watch. Watch it and all of our other stuff. I appreciate you so much. And until next time, landlords, happy leasing.